Hi, hello, welcome to Telugu NRI Radio webinar on US immigration every Wednesday Central Time 6 p.m. So we are doing this community show every Wednesday for giving more information on US immigration, and we'll give some suggestions and right direction on your own scenario, any critical immigration situations. We are trying to give the more simplified and complex immigration system. Yes, today we do have a couple of topics, and we will discuss very deeply, and we'll give the true information behind the scenarios. So yeah, now we will welcome to Lucas Garrison from Burgos Garritson Law Firm, Dallas. Good evening, Lucas. How are you?
Doing well, Venkat. How are you? It's good seeing you again this week.
I'm good. Thank you. So yeah, before going to show, do you want to share anything?
Well, yes. So, again, I see we have a lot of participants lined up for this week, and we always end the show saying this, and I wanted to start off by saying this. We're here as a community support, sharing information. We appreciate everyone who takes part in this forum, and the purpose of our discussion is to help share information so people can make decisions appropriately for themselves and their families. And obviously, a forum like this only is as successful as the participants we have. So please, I think we have quite a few people who are already signed up for today. So again, we appreciate in advance any participation on that matter.
Yeah, yes, yeah, true. The true is a lot of people is connecting the community service, and they are getting more information from this webinar. So we are requesting to everyone. We open multiple ways. You can post your question on Facebook and YouTube chat, or maybe you can send an email to bgimm info.bgmmlaw.com, or we open the conference call. Maybe you can call direct to conference call and directly touch with Lucas and get information about your scenario. So you can connect any time between the show. So we will ask you the question. Maybe we can raise you. Maybe you can start ask questions. So yeah, Lucas, come to the today's topic. Just I want to touch base the 2022 CAP H1B, where we are. Are we applying, or still is any? I don't think there is any roadblock. Just I want to any update on CAP 2022 H1.
So far this year, we've gone ahead and we've successfully started filing cases. We've already received approvals for the H1B 2022 CAP. And, pretty much I think from what we've seen so far this year is we're pretty much going to expect the same outcome as in procedure and process as last year. So if any RFE is issued, I think predominantly what we'll see is RFEs about maintaining status, especially if the person was in F1 status using CPT. We'll just have to forward documentation, much like last year, showing that the person traveled to the college. If not, what's the COVID policy for the school, maybe for remote learning. How the program relates to the degree, and the work that's being offered. So other than that, I think everything's pretty straightforward. Obviously, we're still benefiting from the success of the IT Serve lawsuit from last year that, pretty much removed the Neufeld memo and the third-party offsite employment memo, which made it somewhat difficult over the past couple of years to go through this process. And, we're looking forward to just everything to continue proceeding as is. And as a reminder for anyone who was not able to be selected In the first go around, we are expecting again a second lottery that should take place early in August.
Okay. Lucas, in CAP or any H1 approval, I saw some scenarios here. So sometimes the USCIS request to consular process, and the H1 applicant should leave the USA so and so date. Let's say in this situation, if anything occur kind of this, is there any alternative way to stay in United States? And when we know that the India consulate, it means all consulates are closed. Very tough visa stamping and get back recent days.
Obviously,
so is there any?
Again, we want to first of all acknowledge that right now we're in the middle of a pandemic, and we know right now, India is going through tremendous cases and tremendous burden with this horrible pandemic that's pretty much impacting everyone. I've heard from multiple people, pretty much all families are impacted by this. So having said that, obviously, unless it's a true emergency, we don't want to travel. And your question would be, what if, we get an RFE and the best case moving forward is we don't want just a denial. We want to do a change of status to a consular process. How would this impact me? Well, we've done this in the past where, and of course, everyone's case is unique in its own way. But as a general rule, what we've done is we'll request a consular process, and the student will hopefully be able to maintain their F1 status, and maybe they'll have to continue another semester with their current studies. And 9 times out of 10, if they're still here, we've been able, especially last year, we've been able to file after the CAP a change of status request. Because the person's going to be CAP exempt, and we've been able to go ahead and maybe go ahead and get them in H1 status without them having to depart the country and come back in. There's certain tools and techniques that we can use to do this. And, like I said, even if that scenario plays out, it's not like the beneficiary or the resource would have to leave the United States. There's other procedures we could use to keep them here, so there's not any risk to their health.
Yeah. Okay. So I don't think this year is a pretty much very clear. I don't see any roadblock for H1 approval and the application process. So we are seeing all the Trump administration what was imposed, the new rules is getting rolled back to normal, right? So even you're saying that even the new H1 2021 caps here are getting approved, right? It taking a couple of weeks, or what is the process time is going on for H1 approvals?
So pretty much everything that's been approved so far has been in premium processing, of course. And, as a rule of thumb, it's hard to gauge how fast something would be approved in normal processing because it depends on what service center it's at. So this year, last year, whenever the cases were selected, pretty much on the first lottery, you either filed with Vermont or with California. This year, it's opened up to Vermont, Texas, Nebraska, California. So really, depending on which service center the case is assigned, it kind of you would have to kind of know what the current trends are at that service center for regular processing. But I think last year, the rule of thumb, anything that was not Vermont is going to be about 4 to 6 weeks on average. And of course, Vermont, for whatever reason, is running behind. I think that service center was hit hard with COVID, and I don't know if they've ever fully recovered to catch up on all the work that's been submitted to that service center.
Okay. Yeah. Thank you. Just I want to touch base the H1L2 biometrics. We know that from May 17th, the biometrics is not required for H4 applications. So you see any update for the already filled application, already previous applications? Do you see any process might be, it means for improve the process to get faster H4 approvals and EADs? Did you see any updates on that one?
I haven't seen any updates on the pending cases. However, having said that, there's been even today was officially announced about, rescheduling biometrics. Instead of having to mail in the form, you can call in to the customer service line and reschedule the appointment. So what I think the administration is trying to do, or the agency is trying to alleviate this backlog that we have. And that's going to help us on two fronts. It's going to help us with the H4 EAD and L2 EAD, obviously, but it's also going to help with the GC EAD. That's still going to require the biometrics, and hopefully this process and change will help alleviate the backlog and then speed up the process. So, to answer your question, even if a previously filed case is not exempt moving forward, it should speed up the processing because there's going to be less demand for the for biometrics period, because H4 and L2 will no longer be required to participate with biometrics, and that's going to be for a period of 2 years. Now, we're expecting within this time that a rule is going to be issued to where that's not going to, it's going to be officially rescinded, but as of now, it's paused for 2 years.
Oh, okay. So the pending application, it must process through biometric, right? There is no exemption for biometric process already.
It could be. There could be. So we should be receiving some information as far as the policy moving forward on that. We do know for a fact as of today that any H4 L2 that's been processed or filed after May 17th is not going to have the biometrics requirement at that time. So two things to think about. If you're going to file your biometrics and we file on May 17th, May 18th, next week, we don't need to include the $85 for the biometric fee, obviously. Right. And so then you have to also imagine, what do we do for someone who's paid the biometric fee but has not yet received the appointment? Would that fee be refunded? There's a little bit more to process through all this rather than just canceling everything, because you receive your money back. That's, I think, very important. We don't want the government to receive any unearned fees, especially the government.
Okay. Yeah. Lucas, we can go for next topic is October adjustment of status, 485 adjustment of status. It almost it been 6 months. Most of the Texas or other service centers are not see any biometric progress or biometric letters. It means is service centers are using existing biometric, or maybe they are in process to sending biometric letters. Do you have any update on this one?
So we've been seeing, obviously the biometrics appointments for people who filed with the Supplement J, and those have been processing. I have been seeing a couple here and there of, new appointments being issued for people who downgraded. But, at the end of the day, what we have to look at is, again, the tremendous burden and backlog that there is, and the number of cases that were filed, especially for EAD this last October. So, we want to be patient, but at the same time, a lot of the factors of how fast this processes depends on where you live, because you might have an appointment if you live in Iowa, you have to go to like Des Moines. If you live in Dallas, you have to go to Dallas. So obviously there's different demand for different offices who offer the biometrics.
Okay. So some of 485 application got denied in October month, and USCIS is accepting those reapplications. So still, is there any chance to apply, or is there any timeline USCIS given only timeline who, if any application got denied, hey, you can apply between these times, or still?
I think the correct term would be if the applications were rejected. I don't think, any of the cases would have been denied for not completing the form correctly. They would just be rejected. And USCIS did send letters to a few of the affected applicants where they could be invited to resubmit their corrected forms, or attorneys I guess could write a letter requesting a nunc pro tunc or something like this that, due to the delay in any type of rejection that might have come, we missed the window to file, and therefore the applicant was, erroneously impacted by the agency because of the lack of prompt decision making on their part. That you could have refiled before the final action dates moved into what the dates would be accepted for mailing in an application. So I think to answer your question, I mean, if anyone has that situation still and it needs any direction, obviously we're here to help. I would be more than happy to speak to someone, but there should be a time to, deadline as far as like submitting, but it's best to resubmit as soon as possible. So if there is any issue that's rectified as soon as possible, you don't want to, delay any type of filing or anything, because you might, it might not be timely by the time you do make the request.
Okay. So let's say it means we are seeing the visa bulletin, the final action date is moving. The EB2 is 2 to 3 months and the EB3 is 4 to 5 months. Mm-hmm. Let's say still who applied in adjustment of status in October, still they did not get a biometric and EAD card. And the recent moves, it got final action date. How USCIS behave will send both EAD card and the green card, or first will USCIS will send only direct green card? How does it work here?
So that's a very good question. And let's say an example, this last week we received a green card for a family member, a U.S. citizen. So the spouse of a U.S. citizen. We actually received the green card, a week after the EAD arrived. So, I mean, it was really of no use at that point. But, we have to remember, whenever you file your adjustment of status application and your employment authorization and your advanced parole, you're going off of the filing date. So most people who filed last October still don't qualify to meet the final action date. Now, the final action date is whenever USCIS is going to work on your adjustment of status application. So if the final action date is not current, there's no progress or anything being made on the adjustment of status itself. So what that means is that you're able to obtain advanced parole and employment authorization while you're waiting on those final action dates to move and get current, so your application can be processed. So there's nothing that, hopefully everyone receives their EAD and advanced parole well before their green card, especially for people who filed as downgrade with EB3, because it's still going to be some time. Now, having said that, we can see, again, this historic movement. I'll just reference some numbers here. From March visa bulletin to the May visa bulletin, EB2 moved 8 months, which is, it's unheard of. And EB3 went ahead and moved 7 months. Now, what I can see, and what everyone else listening already knows, is that, we're still going to see historic movement this year leading up to the next fiscal year, which is this October 1st. There's a very good chance some people who might have missed or not filed last fall, their final action date might become current with their priority date. And, some of these people can still file or downgrade or do what they need to do prior to the next fiscal year. But we do know that so many people are moving from EB2 to EB3 to take advantage of this, that, at some point, EB2 is still going to progress, at a faster clip than the EB3 whenever everything balances out. So, that's important to note. It's important, obviously, to pay attention to this forum. This is a great forum, that we can discuss every week, and also every month when the new bulletin comes out, and we can, update everyone like where we're at now, what we believe will happen next month or the month after, so on and so forth. Now, having said that, I do know that there's a lot of questions that come up, and I had a question today from one of my clients who said, Lucas, my priority date is, August of 2011, EB2. What should I do? I've heard from other people I should go ahead and downgrade because the filing date's going to catch up with this, and it would be better this October to go ahead and have this ready, have the I-140 in my pocket so I could go ahead and file. And I know some people on some other forums or maybe another office has been very much pushing this and marking this. And I would just, remind everyone, it's the job of an attorney to analyze and advise based on each individual's case. What I mentioned for client A might not be appropriate for client B or client C. The best thing for me to do and the best way for you to receive advice from an attorney is for an attorney to really analyze each person's case independently, because no one is going to have the exact same case. No one is going to have the same factors of what impacts them as far as their job, their future, their family. And it's my job to look at what the plan is and to say, based on my opinion and what we see on the facts of what's playing out, this is the best course of action for you at this time. And that's a decision we make together. There should never be any reason that you should file just because everyone else is doing so. That's number one. Okay. Number two, what if these dates continue moving at this fast pace and you're really in that EB2 range where the final action date might become current before October 1st? Well, at that point in time, it'd be proper for you to go ahead and file, and you could file concurrently. What if USCIS in July or August uses the filing date instead of filing action date? There's so many things at play. You should wait until you see the facts in front of you before you make a decision like this. And one of the truly important parts of this forum of what we're doing here is to educate people. We're not here to scare people or make people worried they're going to miss something or to do something now. We're here to inform people so they can make wise decisions for not only themselves, but their families. This is not, this is everyone's career, their future. And to just, send out these this panic, and that's really what it is this panic to act now or you're going to miss this opportunity is just really not correct. It's not appropriate. It's not professional.
Yeah, that is a good information, Lucas. But so we are saying the situation, it means everyone surrounding, even Department of Status is saying that from now onwards to the September or October, maybe September is about the end of this fiscal year, it move for every 5 months or every 3 months, EB2 or EB3. So by this number, everyone is calculating themselves. So everyone expecting this year, if in a final action date will move to the end of December 2022 in EB3, maybe 2011 May in EB2. So even everyone projecting or everyone expecting filing date in EB2, maybe it moved to the 2 to 3 years. In EB3, it moves more to 3 to 4 years, right? In this situation, everyone in its confusion state, because everyone looking the opportunity to apply the 485 adjustment of 485, right? So in this situation, they are looking to the others, hey, how they are doing, right? Just replicating other scenario to them and proceeding for applying the 485. So as for your information, the best situation is get touch with the attorneys and analyze their situation, then take a step to apply or not at the moment.
That's what I would recommend. And that's what everyone who makes a prudent decision should evaluate. I mean, you've already invested. If you came here on U.S. Masters, you've already invested so much money in education. If you've been here for 8-10 years on H-1B, that's a tremendous hardship to be in that status that long, to not be able to be an entrepreneur, to not be able to do what you should want to do with your career, and this is a very serious decision to make. It's not something that should be made lightly, and you should never follow the path of everyone else without really thoroughly thinking it through and speaking to an attorney who has your best interest in mind whenever you're discussing this. So what I would recommend is obviously speak to your attorney and go over all the scenarios. And until something happens, I mean, we have a historic movement this year with these dates. We're guessing where they're going to be, but if you have these dates move based upon how many I-140s have been filed at this time with this priority date. So if you can imagine, if you have 20,000 people in EB2 all of a sudden filing to EB3, it does cause a little bit of a balancing act with the way things pan out. So why make that decision to do it early whenever you don't have to? Why spend money or put yourself at risk with RFEs or denial or any of these things before you have to? I mean, that's to me that you would want to have a plan and execute the plan accordingly to what's best for you at that point in time.
Okay. So, Lucas, we are discussing about the numbers and I-140s. Here, it means always the visa bulletin is not understandable. It means based on, I don't know how the Department of State is working behind the mathematical calculation to provide, it means release the every month visa bulletin. Let's say I'm taking the one scenario. Let's say I'm taking my scenario. My priority date is December 30, 2012. Let's say I joined some XYA company in 2012 and applied I-140. Later, 3 years, I changed to the another company and applied the I-140. And after 3 years, I changed to the third company and I applied the I-140. Now the dates are moving. Now I applied to the downgraded. It meant technically or mathematically, I have the four I-140s. So how USCIS take a number of I-140s? You said that USCIS calculated based on the priority date how many number of I-140s. All right. The technical, if you see the only one priority date but having multiple I-140s. In this scenario, USCIS will calculate only one petition or four I-140s.
Well, I think in part of this, we're looking at, obviously your A number would be there, so they would have that information to know, which one, how many unique people or A numbers are there. But what they're looking at too is you have to understand, instead of thinking about the multiple I-140s, let's say in this example, your priority date becomes current. Well, are you in the United States? Are you not in the United States? That's a big question to file adjustment of status. Are you still with the same employer that would sponsor you? So even if it's there and it's a one individual, the government still does not know, and they can only set aside certain percentages. And that's why we move from the filing date to the final action date. There has to be some reserve there because there's only so many visas allotted for that fiscal year. Now, 2 years ago, we saw the pain of how slow it moved with EB2, going barely a month at a time over a 3 or 4 month period. So, obviously here, what we're seeing is there's a large influx of unused visas that are being reallocated for employment base, but there still has to be some type of caution or cushion that's used to where if a visa is applied for, it's still available, because there's only so many visas that are congressionally allocated each fiscal year. So to keep it fair, the government has to know we need to have X amount in reserve, and that's why we use the final action date or at certain times, and that's how those dates might move or adjust, and that's really dependent upon each month how many visas are used or issued, and that's studied, and that's they have their own internal processes to determine that. But that's why those dates move that way, why maybe sometimes dates retrogress like in the past. I know a lot of people have had that hardship, but this year with so many visas that are reallocated, it's not so much worrying so much about that. It's just these dates will continue moving, and like I said, you want to be prepared and you want to be able to make a wise decision whenever it's time to file. So even if the dates become next month, current with whatever your scenario is, you still have that entire month to make the decision and file. There's not anything requiring you to act within a day or two.
Okay. So your conversation, you're saying that eventually EB2 will go forward than EB3 until adjustment of balance between EB2 and EB3. So here, even Department of it means did Department of State will consolidate it based on the alien number or I-140 priority date? How is it? Do you have any information behind that one? Just this question is just understanding how Department of Status is working behind that, so that all H1 holders can analyze their situation. They can apply their priority date, how much, maybe when can get the filing date or final action date.
Well, so there's public information that anyone can access. You can see, and that would be with USCIS obviously for the adjustment of status. You could see the I-140s that were filed and approved with certain priority date in certain visa category and country. Okay, so all that is publicly available, and we can analyze and see that in May of 2011, from India, there were approximately 15,000 EB2 I-140s, right? There's only so much information that we have that we can analyze. We don't have the full record of everything, obviously, for privacy and other issues with that. I can't, access your alien number and your name and everything else to know who's who. Now, having said that, the government, they have access to everything as far as alien number and things like this, and they have their own protocols and procedures to what they use to make these adjustments and movements on the visa bulletin. They coordinate with DOS for that.
Okay. Let's say you said that if final action date comes on priority date, if the 485 holder is out of country, is there any time limit have to have applied the 485, or whenever he come back and he can apply the 485?
Correct. So as long as your priority date is current. So again, just to go over this for our audience, we have two processes. We have an adjustment of status and we have a consular processing. So consular processing means that I'm going to file for an alien benefit, immigrant benefit, and the alien is not here in the United States. So we're going to select a consulate abroad, a country abroad, for the person to process the case. That's one method. The other method would be an adjustment of status, which is predominantly what all of our viewers, are going to go through that process. And what that means is you're in one non-immigrant status, and you're applying to adjust your status to an immigrant, which would be obviously a green card. So if you're here, to go through the adjustment process, you have to physically be within the United States. I've had a lot of people also call me and say, hey, I have an I-140 approved. My priority date's 2010, but I'm currently in India. I'm waiting on maybe a new employer to sponsor me on an H-1s, come back. Is there anything I can do here? And, whoever sponsored that case, you could forward the I-140. There's a process to forward it to a consulate abroad. If the final action date's current, you can go ahead and process your visa accordingly that way. Or, your previous employer can maybe refile the I-140 and port the priority date and then choose consular processing at that point. That's that process. Now, there is time involved with that, and there's no guarantees that things are going to be approved or processed before the dates move again. So maybe they retrogress and you lose an opportunity. So typically what we want to do is try and make sure someone's here to go through the adjustment of status process to help save time. But again, like I said a few minutes ago, everyone's case is very unique and different, and it's up to each immigration attorney to have these conversations with their clients and speak to them individually rather than just as a group. And just like right now, I'm providing general information, not advice that anyone should take, wholehearted as far as like what they should do. I would hope that you would want to talk to your attorney or myself or anyone else to get the best options for you.
Yeah. So actually, I got one inquiry on the scenario. The H1 holder is residing in Canada and using the Nexus card, is working in the United States. So his period in maybe somehow is 2012, August or December. So his attorney is pushed to, once the final action date come, he said that you can prepare within 6 months to apply the 485 adjustment final action date. So he got a doubt. It means whether is there any timeline to apply, or if not utilize those time, maybe he can lose the 485 or something. He got some kind of the confusion state. So whether really have any timeline for apply the 485 once we get the final action date or not?
There is a timeline. Now, this is very important also if you're here on H-1B. Okay, so let's say you have H-1B with a new employer. You have a previous employer who filed I-140. That employer is not going to sponsor you for GC, right? They're not going to give you a supplement J. So now you're trying to start the process with your new employer, but your final action date becomes current. What do I do? Well, if you don't file the adjustment application within that 1 year, whenever your final action date became current with your priority date, you lose the opportunity under AC 21 to keep extending your H1. So while it is important and exciting that everyone's dates are moving, it's also something you have to be very careful about and pay attention to, because let's say if your final action date now is, let's say August of 2010 for EB2, right? Starting today, the clock would start. You have 1 year to file that, or you not only might jeopardize your adjustment filing, but you also won't be able to extend your H-1B beyond the 6 year anymore.
It means he cannot use I-140 for extension H4?
Correct. So there's a limit on that. So the whole purpose under AC 21 for this rule is to say, if you look at it in a vacuum, in a perfect world, the way the law was written was to say, this person comes here on H-1B and you're working, and the employer wants to sponsor you, wants you to have your employment, everything else. Well, the idea would then be to go ahead and process from H-1B to green card. And in the perfect world, in a vacuum, that would all happen before your 6 year in H-1B. But due to the limitations and the constraints with the availability of the visas for EB2, EB3 with India, that something had to change. And that change was AC 21, that allows individuals to extend beyond the 6 year. Also later allowed spouses, instead of waiting an H4 status for 10 years, waiting for the GC to come along, allowed them to also get employment authorization. So there's a lot of things that have been changed along the way that were due to this long processing delay getting for your priority date current.
Okay. Yeah, Lucas, I have the couple of questions today. So the 485 adjustment of status, let's say we applied in October, right? We are waiting for the authorization code and advance payroll. So even after 180 days, is there any process to expedite to get the employment card for 485 adjustment?
So what we're talking about is anything outside of a normal processing time.
Yes.
That's published, you can request, hey, my case is outside of normal processing time. So when you're referring to expedite, there's certain requirements that are needed to have an expedited request. But from what we're seeing, if traditionally and it's posted online that it's a 9-month process to go from filing the application to receiving EAD, that obviously we can say, hey, my case is outside of normal processing times. I think a lot of this will speed up, going back to our original point that we discussed today in regards to the H4 and L2 requirement for biometrics. As soon as that's cleared up, I think we're going to see much faster processing. I think we're going to see a lot of things speed up in that regards to everyone who's currently waiting with a downgraded petition, waiting on their GC, EAD, and advanced parole.
Okay. So I have a scenario, Lucas, about I-140. Let's say, so I applied the I-140 and it turned to after 6 months. Maybe I stay the existing advance company A, beyond the 6 months. So after 6 months, it comes to the AC21 rules, right? So later, after 1 year, once approved the I-140, I move to the other company B, but in between the employee revoked the I-140, right? So even employee revoked the I-140, we can utilize the priority date for future. Let's say if I have any H-1B extension, right? The I-140 got revoked, whether H-1B will be extended or not.
So if you've had an I-140 in this scenario, it technically cannot be revoked unless USCIS revokes for fraud or material representation of fact or USCIS error. So the employer itself, after 6 months, cannot revoke your I-140. So in your circumstance, what you're saying is if maybe I'm close to the end of my 6th year, I finally got my I-140 and it's within that 6 months, and then the caveat with the rule I was discussing is if your final action date becomes current. So if, let's say your EB2 is August 2010 on your priority date, if your I-140 hasn't been revoked by now, it can't be revoked unless it was one of the conditions I mentioned before. So you can easily port the priority date over with the new I-140, or if you already had a pending adjustment status application, you could port after 6 months with a new employer using Supplement J.
Okay. So I have got a couple of questions from Naru. So the first question is, the still waiting for H1 extension receipt number and current you mentioned visa, but current I-94 expiring end of this week. Can I still continue to work?
Correct. You can continue working as long as your current petition was filed prior to the expiration of your I-94. So you could work for 280 days based upon that receipt. If it's an extension, and you can continue working indefinitely if it's a transfer petition.
Okay. But even the without receipt number, he did not get any receipt number.
So whenever we do this, your employer would be the one that would need to verify this information. But whenever you're filing this, your employer needs to update your I-9. Now, as long as your case was filed, like mailed in the mail to USCIS prior to the expiration of your I-94 or whatever the issue is, like if you're filing an amendment as well before you start working at the new location, as long as it's mailed, that's perfectly fine. Now, the employer needs to update your I-9 on the rehire part, and just pretty much, this case was filed on this date, AC-21, and then that would work. Once the receipt comes, they'll update again the I-9 with the receipt number, and obviously once the approval comes, they would have to update again. So that is all that's necessary to keep you compliant as far as maintaining your status to continue working. And as long as your employer is taking care of this, there's nothing to worry about.
Okay. The second question is H1 is denied, and I don't want to go back to India because of current situation. So what are the options I have to continue to stay here until we'll settle the situation in India?
So has the I-94 expired yet, or is it still valid?
He did not mention, but he mentioned that H1 is denied. I'm not sure whether I-94 is denied. It means completed, expired or not.
So basically, if the I-94 was still valid and you filed an extension and it was denied, you could refile again, and you can continue working on the receipt and move forward that way. If that's not an option, or your I-94 expired, you can still refile. There's a possibility maybe of requesting. I've done this a few times where you can request, as a port of entry, the service center. They'll reissue an I-94. So, like I said before, there's circumstances that are unique to everyone's case. There are creative ways of doing this to maybe reissue an I-94 if yours has expired without having to depart the country. But you'd want to discuss that with your employer, their attorney, or any other immigration attorney.
Okay. Lucas, so we have a call and conference. We can take it from him. Margani, do you have any question to ask Lucas? Hello? Nagalin.
Yeah, hey, this is Ishwar.
Ishwar, okay. Yes,
hey, Ishwar.
Okay, so I have a question, Lucas. So just want to check that your again, right? Your thought process on downgrading, from an EB2 to EB3, where your dates are ranging from 2011 and 12. So I would like to know your, or your opinion or suggestion for the folks who are, standing on that line.
Well, thank you for the call, Ishwar. I really appreciate it. What I would recommend, like what we said earlier, is we want to make sure we evaluate and appropriately analyze everyone's situation. I've said this in our previous shows. A process can be similar for everyone, right? The process being, I'm going to file my adjustment of status. I'm also going to file my downgrade. I'm going to do advanced parole and employment authorization for my family, myself. Okay, that's a process. The unique factors that are involved is everyone's case. Everyone's case is going to be unique like a fingerprint. No one's going to have the same case as someone else. So to take advice or to listen to someone to say everyone do the same thing is irresponsible. And I would recommend anyone, we're talking about a lot of time, money, a lot of money invested, not only in just the immigration fees and processes, but you've invested in your career, college, the ability to get to this point to become an entrepreneur, to become a business owner, anything. And that's what we need here in America. And I think that's what we need to focus on is it's responsible to look at your case and to say, look, my goals are ABC. My priority date is this. My relationship with my current employer is this. My attorney, what do you think my final action date is going to be for my visa category, right? That's what we all have to look at and analyze. And to just carte blanche say, I think you should do this just because you should have this in your back pocket and everyone else is doing it is irresponsible. I think you need to really focus and think about what each person is going to do that's going to benefit themselves. It is a tremendous amount of time. I'm speaking to everyone here that at the minimum, you've been waiting since 2010 to get to this point. It's been egregious as far as the amount of time this has taken to get here. And I think, to close this out, everyone should have their own plan and execute that plan accordingly so that they don't miss out on an opportunity. And I hope that helps address your question, Eshwar.
Yeah, thanks, Lucas. I do have a quick follow-up question on that.
Sure.
What are your views or thoughts for EB2, incoming, visa bulletin, or maybe October 2021? Where are you looking? Because you're the first one who predicted that, if I'm not wrong, I'm following, your other blogs, that, you're the first among that, predicted that, you will be having a rapid changes.
Right.
So I would like to know your thoughts on that.
I mean, I think, and I appreciate the comment there, Eshwar. I think, this year we're going to continue seeing historic movement. We've seen, and I referenced this earlier, EB2 has moved 8 months since March. I mean, that's just unheard of for, in years past where we're maybe go through the whole fiscal year with a month and a half movement or progression. So to say anything different, I think, we could see even faster progression, or probably, just to be optimistic and a little bit more conservative with the numbers. I mean, I would say the way things have been moving will continue to move. And, every month that we wait, the president has not removed this ban yet for GCs. So we have a lot of people who are waiting at a consular post abroad, for fiance visas, for marriage-based, family-based green cards. Those are still not being issued unless there's an emergency situation. So what are we doing? So the government's taking all of those visas and reallocating to family-based, right? So unfortunately right now, and I'm sure most of our audience knows that there's a tremendous emergency right now in India, Nepal, Bangladesh, and other neighboring countries in South Asia that has pretty much shut down the region. It's a tremendous pandemic going on. And because of that, there's still going to be this reallocation of visas. So, having said that, I mean, if nothing's being issued or used, and to give you an idea, a couple months back, I think we mentioned that, for all the visas issued abroad, I think that it totaled 20. And to give you a historic number per month, I think typically it averages around 200,000. And this is for the entire world, the visas issued abroad. So think about that. We went from 200,000 in a normal world and a normal processing to 20. Unfortunately, I don't see that increasing anytime soon. And we're going to see these dates continue to move faster. So having said that, let's be, a little cautious. Let's plan. Let's be optimistic and see what we can do to utilize this, to hopefully get the GC faster. Okay. And thanks again for calling, Eshwar, and your questions.
Thanks, Lucas. Really appreciate the service towards the community and taking questions. And thanks to Telugu Radio for facilitating this. Thanks for your community service. Thank you.
Yeah, thank you, Ishwar. Thank you very much for calling today. So, Lucas, we can go back to the question. So from NRI, it means I am on H1 and working on as a manager in plasma collection lab. My amendment is approved for my new location, and I already moved to new location.
Mhm.
But work still not yet started in new location because lab construction still in progress. So my employer running my payroll from my previous location, how long they can run my payroll from previous location, and and would be there any problem in future?
So that's a good question. So technically, your original H-1B from either your last extension or transfer or cap case is at location A. So you probably have a validity period extending beyond the current date. And your employer said, as of a certain date, we're going to have this amendment filed to work at a different location. So your underlying petition is still valid. Your employer can still continue to run the payroll and rely on that petition. At the same time, since your employer followed all the regulations, they have to file this in anticipation prior to you moving to that location. Now, any brief travel back and forth or brief periods of time, a couple of weeks here or there, it's not going to require an amendment. It's not going to qualify as a material change for H-1B purposes. And obviously, I've had a lot of clients, too, that are working remotely. So we've always listed during this time, home address as well. If that happened and you have that listed on your LCA, that would be perfectly fine also to be working remotely. But to answer your question, as long as you're maintaining status in the initial MSA area, which means the metropolitan statistical area, such as if you're in Dallas, it'd be Dallas Fort Worth area, and you're moving to Atlanta. So as long as that initial petition is still valid, you can run the payroll there. You're good to start your employment whenever you move on to the new lab. So if you have any other specific questions with that, you can ask us here or maybe address that with your company attorney.
Yeah, thank you. So I have another question. Can I enter using advanced payroll from India in the current situation?
So it's going to be tricky doing that. I would be very cautious about traveling on a crowded airplane, traveling that long and that far to arrive and to not be admitted. So advanced parole does not guarantee any entry. It's still somewhat of a up to the officer to admit you into the United States. So right now, unfortunately, due to the issue in India, after May 3rd, unless you have like a U.S. citizen kid or LPR or, someone with a green card or something like that, it's a family member, you're not going to be able to get the visa or come here. And you're probably going to also be restricted with advanced parole coming back. So just be mindful of that. There is a quarantine period, I think, of 14 days and other requirements that are associated with that.
Okay. So another question is on GCEAD, if I move to a new location with the same client and employer, do I need to file a LCA and amendment?
So if you want to maintain your H-1B status, the answer will be yes. If you want to move on to GCEAD, the answer would be no. But you want to make sure my advice is, due to this uncertain times, I would want to maintain my non-immigrant status in case something came up or something happened to my underlying I-140, especially if I downgraded. We want to make sure that you're protecting yourself in case something comes up and it's denied. Of course, if your I-140 is denied, your adjustment, EAD, advanced parole, all that will be subsequently denied as well. So I know it's a little bit of an issue right now. It's an extra regulatory step, but I would recommend, if you can, try and maintain your H-1 status at least until we see a clearer window of how things progress, in the upcoming months.
Yeah, thank you. Thank you, Naru, for these questions. Thank you. Just one question from Karan. Do you think USCIS can use up all employment-based visas 263K this fiscal year without wasting them? As per first quarter report, they used only the 27K visas only. Do you have any information on that one?
I think this being, obviously there's only so much you can do at a time as far as processing, right? So at the end of the day, whenever you're issuing visas, part of the equation is going to have to be capacity at the service centers to process everything. We already saw what happened this last October and November, the historic amount of filing. And we saw that with rejections that came about and things like this, by the time you received a rejected package, I think from what I heard, it took until January, maybe February, on a petition that was, or application was filed in October. So if things progress too much, I mean, there's a certain amount of work that can only be done in a certain amount of time. Remember, for employment-based petitions, Donald Trump did issue that new policy. We have to have interviews and things like this. So there still are things that slow down the processing. And, it's not so much of what's allocated or reallocated as it is how much you can effectively process at one point in time. So remember, at this point in time, almost 100% of these visas are being issued as adjustment of status. Okay, so this National Benefit Center, local service centers, they're working on these cases, and then they go to local field offices for final adjudication, interview, things like this. In the past, you would have a fair amount of these would be allocated to where there would be a consular processing case. So now, since we don't have that, everything, the full load is going to be put more on USCIS, and USCIS can only handle and process a certain amount of cases at a certain amount of time. I mean, it's just X number comes in, X number goes out on a monthly basis. So unless they drastically increase their workforce, it would be irresponsible, I think, to reallocate everything at one time. I hope that maybe gives sheds light on maybe the thought process of why that is.
Okay, yeah, thank you. So the Nihar is asking, already we discussed, just asking question, what are your prediction for October 2021 visa bulletin?
I mean, I really think we're going to, especially for EB3, I think for filing dates, I think, not final action, I think filing dates, I think we're going to be well into 2016, 2017 for those, people who might qualify. And I think that as we get closer to that October 1st, we'll have a clearer picture about how far it might move. But I'm expecting, not predicting, I'm expecting it to move that much, and I think it's going to be a busy fall for everyone. I think it's it's going to be historic again in the amount of cases that are filed.
Okay, you meant to say ready for October and maybe prepare for October 2021 and apply first week of October, so that the petition can.
This year, I think everyone should be a little bit more prepared. Last year, I know you and I discussed this extensively prior to October 1st and kind of guesstimating how far things would move. Yeah. And I think still people were caught off guard on really shockingly surprised how fast things moved. And, I think this year, I think everyone's going to be a little bit more prepared and in the right mindset, expecting, the dates to move that fast.
Yeah, that's true. So from Lakshmi, how GC application process will start? Is it based on the application receive date or priority date?
It's based on the priority date. So I think we went over the process in last week's show, and for everyone who might have missed that, whenever you file your case, you're going to have an alien file. That's going to be associated, your alien number is your A number, and it's what's going to identify your case. So all the applications for adjustment status with the evidence, with everything there, is going to actually physically be in a file. and the file is going to be set aside, and your priority date is going to be notated. And whenever your priority date becomes current, your file will then be retrieved, and the officer will begin working on the file. Now, the file will be organized and make sure everything's there for further adjudication. Once the National Benefit Center has determined that, the file gets transferred to the local field office. So if you live here in Dallas, you'll go to Irving, to the USCIS field office there. You'll attend the interview. They'll do the final checks for everything as far as like your to make sure that your supplement J is there, that your medicals are there, and any other information that might have changed or needs to be updated. And then when you go to your interview appointment, the officer's obviously going to have your A file there. They're going to review your application, verify all the information in there. They're going to give you the opportunity to make sure your name is correct, or if you want to change your name, verify the employment with the petitioner, that your job duties are matching, things like this. And then, a decision will be made on your case at that point. But all that starts after the final action date becomes current.
Yeah. Thank you, Lucas, for information. Yeah. Today's we done all questions and topics. I think there's a pretty much very important information today show. Yeah. Do you have any additional information you want to share? Or?
I think if you don't mind, I'd like to, restate what we said at the beginning of the show. This is a wonderful platform. I'm very appreciative of Telugu NRI and you, Venkat, for organizing this, because the purpose we came together in creating this show was to inform the community. And this is more of a community service to make sure we have appropriate information in the community. And if there's any clarification or questions needed, that, we can address it in this forum. Again, I'll open myself up if you want to contact me offline to get more specific information. Everything that we state in this show is more of a general advice, but again, repeating it, everyone's case is very much unique. Any skilled attorney handling your case should be focusing on you as an individual, not as a group, or just because you meet this category and your priority date is this date, that everyone should do the same thing at one time. That's just completely irresponsible. So, I appreciate everyone's input today. You're not just benefiting yourself. These are archive shows, so other people might watch later on who have the same kind of question that you might have. So, I appreciate everyone who participated, and hopefully we can see you next week, every Wednesday at 6 o'clock.
Thank you very much, Lucas. Yeah, thank you everyone who participated today, Ishwar and Aru and Lakshmi and Karan. Thank you very much for your question, and we are requesting everyone participate every Wednesday, and we will discuss about the USA immigration system. So maybe all scenarios will help to the most lot of people in the immigration system. Yeah, a very big thank to Lucas, associated with Telugu NRI Radio, and conducting this webinar every Wednesday 6 p.m. We will be continue the same show, same platform every Wednesday 6 p.m. We requesting participate this show and get more information on the US immigration system. Yeah. Thank you, Lucas. Thank you. Bye-bye.
Thank you.
See you until next week, 6 p.m. Central Time.